Good morning, afternoon, evening, ladies and gentlemen. I was waiting for John to give me the signal that we should start the program. We're doing something a little bit different. As you noticed, last week we had a different intro to the program, and we're still straightening out some of the cues. But we're here and ready to go at 2 o'clock in the afternoon on Monday, as always. And we are glad to have you with us here at WFOV 92.1. And, of course, we are the station allpointstv.com. We're going to continue our discussion about the Constitution. And we were saying last week that there are very few people, even some of the scholars, that really understand the Constitution. And we are going to come behind them and get them straightened out. We're very arrogant about that, I guess. We're the straighten out people. I want to talk about the requirements for the presidency of the United States. But I want to, before getting to that topic, I want to go back over what we've been talking about as far as some of the language that deals with citizenship of the country. And we have some problems there, too. Not only are we having problems in terms of understanding the impeachment process, we're having some problems understanding the requirements for citizenship in this country. Some people are saying, for example, that there's such a thing as birthright citizenship, and that if you come into the country and you have a child while here, even if you're here illegally, or what's the word they're using right now, they are undocumented. And so if you are undocumented and you have a child in the United States, that child, according to some of the persons that are perverting the Constitution, they say that you are a citizen because you're born here on the soil. And they say that that is required by the 14th Amendment. That is so wrong that you hardly can stand these experts that are saying such things. I've been talking about Alan Dershowitz, and I want to just go back over what he said about it. Here's something that kind of leads into that discussion about that. Most folks, I'm reading here from the document Trump Voters. Title of this article is Trump Voters. President should be able to modify 14th Amendment, but not Second Amendment. And it says most folks who voted for President Donald Trump might be fined if he uses an executive order to change the 14th Amendment, an idea he's floated, but not if he came for the Second Amendment. Trump desired change to the 14th Amendment would end birthright citizenship, while the Second Amendment, of course, protects the right to bear arms. So they're saying that Donald Trump would have no problem in terms of putting an executive order into play to change the birthright citizenship that is in fact required, and in fact established in the 14th Amendment of the United States. And they're saying that he would have no problem in doing that in terms of the 14th Amendment, but in fact would stand fast against any change and alteration by executive decree of the Second Amendment, the right to bear arms. And of course, they want to make it into a thing of racism on Donald Trump's part. That is, say, to end birthright citizenship would be an attack upon, quote unquote, as they like to say, the black and brown people who are coming into the country. Not so much the blacks are coming into the country, but the browns coming out of Central America, South America, and Latin America. So the idea is that Donald Trump wants to put a halter on the 14th Amendment requirement that if you have a child here, then the child is automatically a citizen because that is proclaimed in the 14th Amendment of the United States. If you read the 14th Amendment, you'll see how off base that is because, as I said last week, the 14th Amendment says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states in which they reside. Now, Donald Trump is not trying to amend that language. He's not trying to put into place an executive order that would rescind that language or alter it in a way. The language has been altered by those who are misreading it. What they're trying to contend is that the 14th Amendment says all persons born or naturalized in the United States are citizens of the United States. They leave out that middle part, which is a conjunctive phrase that says, and subject to the jurisdiction thereof are citizens of the United States. And that is very important language, because if you are born in the United States to parents who are not citizens, then a child takes on the status, the citizenship status of the parents. And that's very clear based upon the language not only in the Constitution, but also in terms of the language that was passed in terms of the requirement for naturalization. You probably remember that we talked about in Article 1, Section 8, Clause 4, it says that Congress should have the power to pass uniform naturalization laws. That is, say, we want to have the same law for naturalization in Michigan as you have in Ohio, the same in those two states as other states, and that we have to have a uniform naturalization policy that applies to all the states the same way, and therefore the nationalization, the naturalization of the requirement for citizenship shall be uniform according to Article 1, Section 8, Clause 4, in all 50 states. So you can't have one requirement for naturalization of citizenship in one state and then have a different policy for naturalization in another state. It must be the same in all 50 states. One policy throughout the United States. So we look at the, we want to apply that in terms of the requirement for president. And to be the president of the United States, I'm looking for the language here of the meaning of natural-born citizen. What does it mean to be a natural-born citizen? Because there are two types of citizenship. One is natural-born, to be a natural-born citizen, and the other one is to be a naturalized citizen. And it's a naturalized citizenship that that they tried to define in 1790, and I'm going to look for the copy of it. I thought I had it here. Yeah, I do have it right here. The Federal Naturalization Act of 1790 and 1795, when the Congress was carrying out its constitutional responsibility under Article 1, Section 8, Clause 4, to set up a uniform naturalization law that applied to all of the states, so that we could have one policy in terms of how those who are not citizens but would be naturalized become citizens, and so on. And here's what it says. There are two laws. I'm going to read one of them, and then I'm going to read part of the other. The Federal Naturalization Law of 1790. Be it enacted by the Senate and House of Representatives of the United States of America, in Congress assembled, that any alien being a free white person who shall have resided within the limits and under the jurisdiction of the United States for the term of 2 years may be admitted to become a citizen thereof for the term of 2 years, may be admitted to become a citizen thereof on application to any common law court of record in any one of the states wherein he shall have resided for the term of 1 year. So being in the country 2 years being a resident of the state in which you are, in fact, making the application to become a citizen, a naturalized citizen. In that state, you have to be there for 1 year and making proof to the satisfaction of such court that he is a person of good character and taking the oath or affirmation prescribed by law to support the Constitution of the United States, or affirmation prescribed by law to support the Constitution of the United States, shall administer, and this oath shall be administered, and the clerk of such states shall record such application and the proceedings thereof, and thereupon such person shall be considered as a citizen of the United States. All that is very good in terms of the naturalization process, but here's where we run into a problem. And the children of such persons, so naturalized, dwelling within the United States, being under the age of 21 years of age, shall also be considered as citizens of the United States. So what that is saying is that the person going through the naturalization process, if the person meets the requirement, notice it says here a free white person, meaning that not all whites in this country at this time were free. Some were indentured servants. So they would not, based on this language of naturalization, be under the auspices of this language. They would be excluded from the language, as a matter of fact, because free white person is the requirement for naturalization. 2 years in the country and 1 year a resident in the state in which the application for citizenship is in fact made. Then it says, the children of such persons so naturalized, dwelling within the United States, they have to be in the country, shall also be considered as citizens of the United States. In other words, if the parents are naturalized citizens, then the children of parents so naturalized shall also be citizens. But what kind of citizens? They will be naturalized citizens, taking on the citizenship of the parents. And the children of citizens of the United States that may be born beyond. Now, this is a problem right here. And I'm going to ask you later on, why is this a problem? This is a problem right here, this part of it. Don't forget now, we're talking about a uniform naturalization policy that will apply to all 50 states. At this point, all 13 states. But now today, all 50 states. Here's a problem here of this. And I'll ask you later on to clarify why this is a problem. Think about this for a minute. And the children of citizens of the United States that may be born beyond sea or out of the limits of the United States shall be considered as natural-born citizens. So we were talking about naturalization citizenship. Then it goes into natural-born citizenship. And the children of citizens of the United States that may be born beyond sea or out of the limits of the United States shall be considered as natural-born citizens. This is the only place where there's an attempt to define what is meant by natural-born citizens. Now, the problem with this is that we were talking about Congress has the power to create a uniform naturalization process for citizenship. But now they ventured into something different from that. They're now talking about natural-born citizenship. And this was the Naturalization Act of 1790. Now, 5 years later, Another act was passed by the Congress, and this act was one that was written by James Madison. Now, in Article 4, Section 4 of the Naturalization Act of 1795, it says this: "And be it further enacted that the act instituted, quote, an act to establish an uniform rule of naturalization passed the 26th day of March 1790 be and the same is hereby repealed." What that means is that the Act of 1795 repeals the Naturalization Act of 1790. And the question is, why was it a repeal of the Naturalization Act of 1790? And let's see how it does that, how it repeals it. I won't read the whole. This one is very long. I won't read the whole bill. What I'll read is Section 3, which is a major part of what's repealed, how it changes the Act of 1790. So the Act of 1795 replaces the Act of 1790, and it does it in this very particular way and this very important way. In Section 3, it says this: "And be it further enacted that the children of persons duly naturalized, dwelling within the United States, and being under the age of 21 years at the time of such naturalization, and the children of citizens of the United States, born out of the limits and jurisdiction of the United States, shall be considered as citizens of the United States." Now, what's the difference between that language and the language of 1790? Here's what 1790 says. Read that again to you. "And the children of such persons so naturalized, dwelling within the United States, being under the age of 21 years of age, shall also be considered as citizens of the United States." And then it goes beyond that to talk about natural-born citizens and says, "And the children of citizens of the United States that may be born beyond sea or out of the limits of the United States shall be considered as natural-born citizens." You see a problem with that? What did Article 1, Section 8, Clause 4 say again? It says that Congress shall have the power to enact a law of naturalization citizenship. And it does that at the very first part of the language, but then it goes into natural-born citizenship. And Madison, James Madison, who wrote the language in 1795, makes another statement which repeals 1790, and here's how it repeals it in this particular place of importance. The whole act was repealed, but here's how it differs from 1790. See if you can catch it. "And be it further enacted that the children of persons duly naturalized, dwelling within the United States, and being under the age of 21 years at the time of such naturalization, and the children of citizens of the United States, born out of the limits and jurisdiction of the United States, shall be considered as citizens of the United States." What did you notice there? You notice that it does not say natural-born citizens of the United States. They shall be considered as citizens of the United States. And the Act of 1795 is very important because it does something that many of the scholars have missed in terms of what happens in 1795 that corrects something that took place in 1790 that went beyond the claims that can be made in the Naturalization Act. The Naturalization Act, Congress can create uniform law of naturalization. What Congress cannot do is that Congress cannot pass a law that amends the Constitution. And that's what the law of 1790 does. It's okay to put a uniform naturalization process in place. But when it does this right here, when it says, and the children of citizens of the United States that may be born beyond sea or out of the limits of the United States shall be considered natural-born citizens, that's not the naturalization process. That is, in fact, now talking about natural-born citizenship, not naturalization, not citizen naturalized, but citizens that are natural-born, and that goes outside of the orbit of the control of Congress under Article 1, Section 8, Clause 4. Because that particular part of the Constitution does not give the Congress the power to amend the Constitution. You can only amend the Constitution by proposing it, 2/3 of the House and 2/3 of the Senate proposing an amendment, and then it has been referred to the states, where 3/4 of the states must ratify it. Congress cannot amend the Constitution by passing a law that would amend the document. And that's what it would do if that stood. If what is passed in 1790 stands, where it says that, and the children of citizens of the United States that may be born beyond sea or out of the limits of the United States shall be considered natural-born citizens, that amends the document. In other words, it's saying something here that's obviously not said in the document. Otherwise, why would they add it there?
I wish I had that. You just sent that to me. You needed that section so I could put it up. What section is that again?
Put that up if you can, John.
I don't have it though. I can't. It's going to be hard for me to get it right.
Hard to get. Okay. Yeah. The Federal Naturalization Law of 1790.
Okay. See,
we did that once before though. In terms,
I'll see if I can. Okay. So it's a Federal Naturalization.
It's a Federal Naturalization Law of 1790.
Okay.
See if we can bring that up, because I need to show that, because it is very important that we understand what is happening here with this language. They have the power under Article 1, Section 8, Clause 4 to pass a uniform naturalization law. We don't want to have one state following one law and another state following another law. Creates chaos within the body politic. So Congress is given the authority to pass a uniform law that all states follow, that gives us one law for naturalized citizens of the United States. Those who are not natural born, but will become citizens based upon the naturalization process. That's what is being spelled out here in 1790. 2 years after the Constitution was ratified, they're now passing a uniform naturalization law called the Federal Naturalization Law of 1790. John, see if we can find that, because I wanted to. I'm sorry about that. I didn't. I should have.
Okay, sorry. Federal Naturalization Law 1790, then 1795.
Right.
And then it says, United States Congress enacted to establish a uniform rule of naturalization to repeal the therefore passed on that subject in January 29th, 1759. So it's like, but I don't know if I got the right document.
Yeah, now it should say United States Congress enacted to establish a uniform rule of naturalization, March 26, 1790.
I'll see if I can grab it then, okay?
Okay. Right. See if you can grab that so we can show it to the viewers. I want to make sure we understand this, because it's interesting how we're saying that the Constitution does not define natural-born citizen. And they're trying to, in this language here, they're trying to, in the Naturalization Act, they're trying to talk about natural-born citizen, and that's not what they are allowed to do under Article 1, Section 8, Clause 4. Clause 4, Article 1, Section 8, Clause 4 says they have the right to set up a uniform naturalization act, not to define a natural-born citizen. So the first part of that is fine. It does that in the first part. It sets up Uniform Naturalization Act. John, do we have it up there yet? Okay.
No, not yet. No, because it's like I'm trying to save it, but it's going to save it as the entire page. And when I put it up on here, it won't actually show it; just show the URL. So anyway, I'm trying to get it right now. Okay.
Okay. All right. That's fine. What I'm getting at here, though, is that it does what the Constitution requires and allows the Congress to do, but after setting up a uniform naturalization process, saying
by the way, we already slipped into break, so if I didn't get it, I missed my cue there, so I went into the break.
Yeah. Okay. We're gonna get it right here. I want to take my time to make sure you understand it, because I don't know why the scholars can't understand the Constitution, and they can't see what happened here. What happened here was they carried out the mandate. They did, in fact, pass a naturalization act that's uniform. They did that. But after having done that, they then went into something that goes beyond the call for them to pass a Uniform Naturalization Act. Article 1, Section 8, Clause 4 does not tell the Congress to amend the Constitution and tell us what the document of natural-born citizenship is and define that in the Naturalization Act, because then it's a natural-born act, and you can see here that it's a Federal Naturalization Act. It's not a natural-born act, because you cannot amend the Constitution through an act of Congress. In order to amend the Constitution, you must have, according to Article 5, you have to have 2/3 of the House and 2/3 of the Senate. They must propose an amendment. And then, because the states are the compelling force, it requires 3/4 of the state legislatures to ratify the proposal. So after 2/3 of the Congress, that means 2/3 in the House, 2/3 in the Senate. 2/3 in the House would be 290 members. 2/3 in the Senate, if they're all present, would be 67 members. If they then propose an amendment, then the proposal is then passed to the states. It takes 3/4 of the state legislatures to ratify the proposal. And upon 3/4 of the states ratifying it, then that proposal becomes an amendment to the Constitution. The Congress, members of the House, the Congress, members of the Senate, they must propose the bill. Then the state legislatures, 3/4 of them, must ratify the bill. And if they ratify the bill, then that bill, it becomes a part of the Constitution. It amends the Constitution in that regard. But you cannot, the Congress cannot, on its own accord, amend the Constitution through the naturalization process. Federal naturalization laws, you have the authority under the Constitution to do that, but there's no authority in the Constitution to amend the Constitution and change what, and put in there what is meant by natural-born citizen. Now, there are a lot of people that say that natural-born is not found in the Constitution, and I do not agree with that, because that's not true. I'm going to show you that it is found there, but those that are reading it are not clear about what's being said here. Okay, we're coming back from the break with WFOV. And what I'm writing about here is that the Constitution does make it clear of what you mean by natural-born citizen. And I want to go around it for a minute, but I'm going to come back at the end to talk about what the Constitution says. And John, get ready.
I do have it up.
I do have it up now?
I'm going to have it up. So I'm going to have to put it over you, though, so people can read it.
Okay, fine.
So
that's good.
So
I want to read from the Naturalization Law of 1790.
Okay.
And let me read it again. And I'll show you where they get off track in terms of what they're required to do. They did that, but then they did something they weren't required to do and they couldn't do. and they went beyond the call and did something totally different than what the claim was in Article 1, Section 8, Clause 4. You can, in fact, pass a Uniform Naturalization Act. What you cannot do is that you cannot then go from that and then talk about what it means to be a natural born citizen. Because we're not talking about naturalization anymore. We're talking about natural born at this point. And it's a whole different thing here. And that's not what's authorized in Article 1, Section 8, Clause 4, which authorized Congress to pass a naturalization bill, not to pass a natural born bill, which is what they did in the last part of that. Now that we have it on the screen, let me read it again, and I want to point out where they went off of the mandate. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assemble that any alien, and we don't want to use the word illegal alien now, we want to talk about an undocumented citizen, that any alien being a free white person who shall have resided within the United States and under the jurisdiction of the United States for the term of 2 years. What that means is they have to be in the country for 2 years under the jurisdiction of the United States. You can't leave and then go back and come back. You have to be 2 years under the jurisdiction of the United States. That person then, being here for 2 years, may be admitted to become a citizen thereof on application to any common law court of record in any one of the states wherein he shall have resided for the term of 1 year at least. So 2 years in the country under the jurisdiction of the United States, meaning you can't leave the country and come back because you have to be there and be here in this country for 2 years under the jurisdiction of the United States, and then 1 year in a state in which you're going to file the application, taking the oath of affirmation. It says taking the oath or the affirmation. Some may have an objection to saying, I swear. So if you have an objection to that, then you could take the affirmation, I affirm, which is the equivalent of saying the same thing. I swear, or you can say, I affirm to support the Constitution of the United States, which oath of affirmation such court shall administer, and the clerk of such court shall record such application and the proceedings thereon, and thereupon such person shall be considered as a citizen of the United States. Now, what kind of citizen of the United States? A naturalized citizen of the United States, which is in the purview of what is allowed to the Congress under Article 1, Section 8, Clause 4, where Congress has the authority to pass a uniform naturalization law. And that they've done. So far, so good. And the children of such persons so naturalized, dwelling within the United States, being under the age of 21 years at the time of such naturalization, shall also be considered as citizens of the United States. Okay, the parents have been naturalized. Therefore, the children of the parents so naturalized under the age of 21, those children under the age of 21 are also naturalized citizens, taking on the citizenship of the parents. The parents are naturalized, therefore the children are naturalized. Again, so far, so good, no problem. No problem here. Here's the problem. Now these persons are trying to define what is meant by natural born citizen. And that's not the authorization of the Constitution. The authorization of the Constitution is to make the uniform law of naturalization. They are now going into natural born. And here's what it says beyond the mandate. And the children of citizens of the United States that may be born beyond sea or out of the limits of the United States shall be considered as natural born citizens. And the scholars, these constitutional scholars, so-called, are saying that 8 of the members of the committee, there were 11 members on the committee that drew up the naturalization law of 1790, they're saying 8 of them were at the Constitutional Convention where natural born citizenship was placed in Article 2, Section 1, Clause 5. John, can we put that back on the screen? Can we put Article 2, Section 1, Clause 5 on the screen? Where it talks about the requirements for the president. Okay, can we put that up there? All persons born, it says here that the president, to be president, the requirement is the person must be natural born. And they put that there first because if that requirement is not met, natural born citizenship is not met, then the other requirements don't matter. You have to be a natural born citizen. Natural born, they're trying to clarify it in the Federal Naturalization Law of 1790, but because they're assuming that it's not clear in Article 2, Section 1, Clause 5, natural born citizenship. They claim it's not defined.
I just saw something that clicked in here because you keep on repeating this, and I saw this reading: no person except a natural born citizen or a citizen of the United States at the time of the adaptation of this Constitution.
That's it, John.
And it's like, so when it was formed, the country was formed.
John,
yeah.
The scholars cannot read. That's the problem. You see that part there? That part is very important. It's just like what I was reading in the 14th Amendment. You see, they do not understand how to connect the language. You see, the problem is this. Let me read something else real quickly here that makes the point. Let me read something here that I think would be a prelude to making the main point. This is the Gettysburg Address. Listen carefully to what Abraham Lincoln said in the Gettysburg Address that was given November the 19th, 1863. This is commemorating the Battle of Gettysburg was fought July 1, 2, and 3 of 1863. And what Lincoln is doing is going back to the battle in Gettysburg, and he is commemorating those deaths that occurred there. And here's what he says. He says, 77 years ago, our fathers brought forth on this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. So if you say that the Gettysburg Address is given in 1863, and Lincoln is saying 77 years ago, a new nation, this nation was brought into existence, all we have to do to see what he's talking about is subtract 87 years, because 4 is 80 years, 20 years to each score, so 4 is 80 years. And he says in 7 years, so 7 years ago, our fathers brought forth from this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. So 87 years from 1863 is 1776. Okay? So in 1776, we have a new nation created. Now, if you say that the president must be a natural-born citizen and he must also have reached 35 years of age and 14 years a resident in the United States, if the country is born in 1776, then what president meets the requirement of those three requirements for being eligible to be president of the United States? And the answer is none of them are. Natural-born citizenship, you cannot have been a natural-born citizen because at the time of the birth of the first, the first 7 presidents, Mon Van Buren is the first person that could fulfill the requirement of that language, natural-born citizen, if the caveat is not put in there. Let me read let me clarify what I'm talking about here. Keep in mind, the country is created according to what Lincoln was saying. The country was created in 1776. 7 years ago, our fathers brought forth in this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. That means the founding of this nation is 1776, based on what Lincoln said. Okay? George Washington was born 1732. John Adams, born 1735. The third president, Thomas Jefferson, born 1743. James Madison, the fourth president, was born 1751. James Monroe, the fifth president, born 1758. John Quincy Adams, the sixth president, born in 1767. Andrew Jackson, the seventh president, born in 1767, the same year as John Quincy Adams. The first president that would be born in the United States and therefore be natural born would be Martin Van Buren in 1782. So what did the framers in their brilliance? And John, you pointed it out. You pointed it out. What they did in their brilliance is that they recognized that none of the persons that were there at the convention, based on the fact that they were born before the nation was born. The nation was born in 1776.
I don't think Alexander Hamilton could actually have been qualified because he wasn't born in the United States.
But he would have qualified.
He would have? Okay.
Yeah, because look at this language you just pointed out. Look at what it says there.
Yeah, see, I just
see it. You see how it preempts? It preempts and says those that are natural born, and then read that language, John, up there on the screen about. Read all the language there.
Okay, Article 2, Section 1, Clause 5.
Yes.
No person except a natural-born citizen or a citizen of the United States at the time of the adaptation of this Constitution shall be eligible to the office of President. Neither shall any person be eligible to that office who should not have attained the age of 35 years and have been 14 years a resident within the United States.
You see what it does there? It includes the ones who cannot fit the requirement of natural-born citizenship by making an exception for those persons. See, here's the confusion that many people have. You know, when I was quoting the preamble to the Constitution, and I said that the preamble says, we, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessing of liberty to ourselves and our posterity, do ordain and establish this Constitution of the United States of America. We are ordaining it to ourselves and our posterity. What it does there is that it deals with the posterity first in terms of that language in Article 2, Section 1, Clause 5. A natural-born citizen, you have to be natural-born in terms of the posterity aspect. It's reversed there. But in the particulars of the moment, it says for those persons that were not qualified today, then it excludes them from the requirement because nobody is eligible to run for president under that language because it requires you to have been a natural-born citizen and 35 years of age, and no one meets that requirement because the country is not born yet. So all the ones I read, George Washington, John Adams, Thomas Jefferson, James Madison, James Monroe, John Quincy Adams, Andrew Jackson, all those persons are preempted from having to follow the language because they are excluded specifically from the requirement of natural-born citizen because the country does not exist at the time of their birth. And that's why that caveat is put in there. You see that, John? That's important to understand that they are retroactively preempted from the language. But because the Constitution is drawn up for the posterity as well, all the ones who are not citizens at the time of the country's birth, you see how it says that those that were citizens prior to the Constitution being drawn up, those that were citizens as of 1776, that language does not preclude them from running for office, for the presidency. But all the others that are not citizens at that time, it does preclude them. They're not natural-born citizens. But it makes clear that they're not natural-born under that language. They're not natural-born because the language says you must be a natural-born citizen. Why are they excluded from that language? But they're given a preemption. They're given a restitution from the language because it puts a caveat and says that those that are citizens at the time of the Constitution being ratified, if they were citizens at the time the country is born in 1776, they are excluded from the requirement of natural-born citizens. Why does it put it in there? Because they are not born under the auspices of the United States. They are born before the birth of the United States. They are born under the polity of Great Britain. And therefore, so that the language does not preclude them from running for president, it makes an exception to them in the language by saying that those that are citizens of the United States at its birth, and that birth would be July the 4th, 1776, those that are excluded from that language, they can run for president. We're going to, in fact, incorporate them as being able to run for the office, even though they're not natural-born under the language. We're going to exempt them because how could they be natural-born if the country wasn't born yet? They were born as subjects of the British. So they are given an exemption. Everyone else, though, who are not citizens at the time of the Constitution, they must have natural birth citizenship. Now, there are those who are saying that Article 2, Section 1, Clause 5 does not define what is a natural-born citizen. These people are unable to read the Constitution. Article 2, Section 1, Clause 5. No person except a natural-born citizen, or, here's the exemption for those that were citizens at the time of the country's birth, or a citizen of the United States at the time of the adoption of the Constitution. George Washington, 1732, a citizen at the time of 1776, and a time of the Constitution. When the Constitution is ratified, George Washington, having been born in 1732, in the country at that time, George Washington, although born under the British flag, is given an exemption. So is John Adams, 1735 is his birth date. Thomas Jefferson, 1743. James Madison, 1751. James Monroe, 1758. John Adams, 1767, and also Andrew Jackson, 1767. They are exempted from the requirement of natural-born citizenship. And where is that exemption found? Where it says this: It says, no person except a natural-born citizen or a citizen, that word or a citizen of the United States at the time of the adoption of the Constitution. Those who are citizens at the time of the Constitution are exempted from the requirement of natural-born citizen. In other words, they're not natural-born, but they're exempted because it's impossible for them to be natural-born if the country did not exist. They're born, so how are they born? They would normally be naturalized citizens. But because you can't hold them to that account because the country doesn't exist at the time of their birth. The country does not exist until 1776. Before that, they are subjects under the British. So they would not qualify. So the Constitution gives them an exemption. That's what's happening here. But they're trying to say that it does not define natural-born citizen. Yes, it does. By incorporating them in a way in which they are incorporated into citizenship, it is saying here that otherwise they will be naturalized. But because you cannot call for natural-born in their cases because the Constitution was not drawn up at that point, and that they were not they were born before the country was born in 1776, you cannot hold them to the language. So it makes an exception to them. Or, you see the word or there, or a citizen of the United States at the time of the adoption of the Constitution. They are exempted from natural-born citizen. So are they natural-born? No, but they are given an exemption. Is that right, Alan Dershowitz? We have people that are illiterate. You see the exemption there? No person except a natural-born citizen or, here's the exemption to it, or a citizen of the United States at the time of the adoption of the Constitution shall be eligible to the office of the President. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and been 14 years a resident within the United States. Now, are the rest of the requirements met by George Washington, John Adams, Thomas Jefferson, James Madison, James Monroe, John Quincy Adams, and Andrew Jackson? Are the other requirements met? Yes, they meet the other requirements. They're 35 years of age. They reside in the United States for 14 years. All that is met. The only thing that's not met is a natural-born citizenship is not met. And they are given an exemption from that requirement by saying that they were citizens at the time of the ratification of the Constitution. If you're not a citizen at the time of the ratification of the Constitution, then natural birth is a requirement. George Washington all the way up to Andrew Jackson, these are naturalized citizens of the United States. But because they are not natural born, nor could they have been natural born, they are given that exemption. That's what that word or is, that's why it's there. In the second article, Section 1, Clause 5. Is that right, Alan Dershowitz? Is that right or wrong? The mere fact that the exemption is there clarifies what you mean by natural born. Because you have to understand something here. And nobody has pointed this out. They're trying to act like this is hard. This is not hard. This is very simple. These persons, George Washington down to Andrew Jackson, from the first president to the seventh president, every last one of those persons were naturalized. If you're naturalized, you cannot become president. But because everyone was naturalized at that point, Nobody could have met the requirement of 35 years of age at that point. I should say, nobody could have met the requirement of natural born at that point, because the country was only born in 1776. If you date that age at that point, let's subtract let's subtract 1732 from 1736. Or, okay, these other dates I gave you. John Adams, 1735, Thomas Jefferson, 1743, Andrew Jackson and John Quincy Adams, 1767. You cannot meet the requirement at that point, because 35 years of age, there's a problem maybe not the age would be a problem. The problem would be that they're not meeting the natural born citizenship, because the country does not exist 35 years at that point. In other words, when they're born in 1732, they're not natural born, because the country does not have an existence at that point. So therefore, the Constitution makes an exemption for them. Anyone, therefore, who is not a citizen at the time of the ratification of the Constitution, those persons must be natural born. Now, those persons born outside the country then, those persons that's not born inside of the United States, under the flag of the United States, inside of the 50 states, those persons are not eligible to run for President of the United States, because they're not natural born citizens. They are no longer given a preemption from the language. And that's what is found in Article 2, Section 1, Clause 5, if you can read it. And the scholars obviously have not been able to read it. That's why they are confused about the natural born citizenship. You must be born in the United States in order to be eligible to run for President of the United States today. Okay, I got to get out of here, but that's the honest gospel truth. Take that to the bank. Until next week, I want you to follow your dream, because if you don't follow your dream, you'll never know what's on the other side of the rainbow.